Welcome to The Explainer. Today we are diving into a really fascinating Supreme Court case, one where following one law could actually mean you're breaking another. This is the story of Louisiana v. Callais.
So think about that for a second. How is it even possible for a state to get caught like this? Well, we're looking at a classic legal catch-22, where two huge federal mandates, both meant to make sure elections are fair, seem to be pointing in completely opposite directions. Let's dig into how that can happen.
You know, the whole problem really boils down to this tension between two incredibly powerful legal forces in our country, both designed to protect voters, but in very different ways.
Okay, so on one hand, you've got Section 2 of the Voting Rights Act. Its whole job is to stop something called vote dilution. That's just a fancy way of saying you can't draw voting maps that slice up minority communities to weaken their vote. But on the other hand, you have the 14th Amendment's Equal Protection Clause, which says the government absolutely cannot use race as the main reason for its decisions. You can probably already see where these two are about to collide.
And that collision brings us right to this term, racial gerrymandering. It's a really crucial idea. See, the Voting Rights Act says states have to be aware of race to make sure they're not discriminating. But the Constitution draws a very bright line. It says you can't make race the #1 overwhelming reason for how you draw districts' lines. That's a huge no-no.
All right, enough with the theory. Let's look at the actual case, Louisiana versus Callais, and see how this abstract legal fight played out on the ground, with some very real-world results. And wow, did this happen fast. So back in 2022, a court looks at Louisiana's map and says, nope, this likely violates the Voting Rights Act. You need to draw a second majority black district. So the state goes and does exactly that. But then, almost the second they do, a totally different group of voters turns around and sues them, arguing that by following that court order, they just broke the Constitution. Now, the court that heard the second case was immediately blown away by the shape of this new district. They described it as this sprawling, 250-mile-long thing that kind of snaked across the state, just to connect these separate pockets of black voters. For the court, this was a massive red flag. It looked like race, not things like geography or keeping communities together, was the only thing that mattered. And here's the kicker. The court didn't even have to guess why the map looked like that. The map's own sponsor said it out loud, on the record. He basically said, look, we all know why we're here. The court told us to draw a black district, so that's what I did. I mean, that's pretty much the definition of a smoking gun. It confirmed that race was the primary factor.
So this entire constitutional mess gets thrown in the lap of the Supreme Court, and it just exposed this massive divide among the justices. And honestly, the best way to get what's going on is to look at this really powerful dissent written by Justice Thomas.
His main point is that the Supreme Court basically created this problem itself. He calls it an intractable conflict, a fancy term for an impossible situation where states are trapped. He argues the court's own recent rulings on the Voting Rights Act are now forcing states to do the very thing the Constitution says they can't.
And he names names. He points right to a huge case from just last year, an Alabama case called Allen v. Milligan. According to his dissent, that's the decision that really put the Voting Rights Act on a collision course with the 14th Amendment.
And this slide really breaks down his argument perfectly. So, step 1, the Milligan case set up this rule that if voting in a state is racially polarized, that state has to create majority-minority districts that are roughly proportional to the population. Step 2, that kind of voting is actually pretty common, and with today's mapping software, it's super easy to draw these districts. So what's the result? Step 3, states are now basically forced to make race the main thing they think about, creating what he calls palpable racial gerrymanders, exactly what the Constitution is supposed to forbid.
So the dissent argues that this just doesn't work. You can't have it both ways. The court's own interpretation of the Voting Rights Act now requires using race to classify voters. But the court has also said for years that doing that is so dangerous it demands the highest level of review, something called strict scrutiny. And the dissent's point is there's no way this VRA test can survive that high standard.
So you've got this massive, fundamental conflict staring the justices right in the face. They were asked to fix it, so what did the Supreme Court do? Well, in a really strange move, they punted. They just decided not to decide. After all the briefs, all the arguments, they basically said, you know what? We're going to send this back and have you all re-argue it later. This leaves that huge legal question just hanging in the air, and it leaves Louisiana completely in limbo.
And look, this inaction has huge real-world consequences. This isn't just about Louisiana. Right now, states all over the country are left trying to guess how to draw their maps legally. The whole point of one of our country's most important civil rights laws is now kind of fuzzy. And maybe the biggest takeaway is that this signals the 9 justices themselves are deeply, deeply divided on how to handle one of the most fundamental questions in our democracy. What does fair representation really mean?
So ultimately, this whole case leaves us with a really deep question that the Supreme Court still hasn't answered. When does a tool that was designed to fix racial discrimination cross a line and risk becoming a new form of racial classification itself?
This is for entertainment and educational purposes only. This is not legal advice.